Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt. Now it's time to discover your hidden legal issue blind spots by listening to me talk about the law on the radio. And today I'm going to be talking about estate planning deficiencies, and I have a checklist for you if you call the show or if you email me. So you can ask a question right now on Saturday, May 9th, 2026. Just call 210-308-8867, 210-308-8867, or email me at host@talklawradio.com. That's HOST@talklawradio.com. In the subject line, put deficiencies or checklist, and in the body of the email, just tell me where you're listening from. So the first deficiency is, you probably guessed it, not having a last will and testament. So when should somebody have a last will and testament? Well, the first clue is you're over the age of 18. Everybody over the age of 18 should have a last will, durable power of attorney, medical power of attorney, authorization to release health information, and maybe a directive to physicians. If you don't think you need a last will, call me right now, May 9th, 2026 at 210-308-8867, 210-308-8867, and challenge me on this. Tell me why you don't need a will. Okay. The second clue that you need a last will and testament is when you have children. The law allows you to nominate a guardian if you die, to be guardian for your children after you pass away, and you can name that person in your last will and testament. Why is this so important? So you can make sure that somebody with your values is going to be raising your kid instead of somebody that doesn't share your values. You wouldn't want somebody with a different religious belief raising your kids, would you? No, you want it to be raised as closely as you would. At least that's the way I thought about it. When I started working for another estate planning attorney decades ago, I had to have this meeting myself. And my wife and I, we didn't have agreement on that question because we had never talked about it. Not until we got to the meeting with my boss, who said, "Who's going to be guardian of your children?" Also, you don't want your relatives fighting over custody of your kids. We want to prevent as many fights as we can, right? Because we want peace and family harmony. We want those family relationships to last so that we can count on each other when things go wrong. And you want everybody to know that it was your idea that person be guardian. And when it's written down on paper, signed in front of witnesses and a notary, everybody knows that was real. And it's legally enforceable as well. Another clue that you need a last will and testament is when you buy a house. If you pass away, somebody needs authority to transfer title to the beneficiaries, or someone needs authority to sell the house. Well, in a last will and testament, you nominate an executor to have that authority. The next question is, when should I update my estate plan? Well, I'm going to give you some dates, and you can write down these dates if you're taking notes, or if you're in the car, just remember to email me at host@talklawradio.com. That's HOST@talklawradio.com. In the subject, put checklist, and in the body, tell me where you're listening from, and I'll email you this checklist document for you to self-evaluate whether you need to update your last will, living trust, or tax-protected inheritance plan. So the first day I want you to remember is January 2nd, 2013. If your will was signed before that date, or if your trust was signed before that date, it probably doesn't include provisions that refer to the American Taxpayer Relief Act of 2012. In that law, Congress and the President made a portability election permanent. That's where the surviving spouse can use the deceased spouse's unused exclusion amount for estate tax purposes. And so if your will or trust was signed before that date, it needs to be updated because the law changed. So go into your safe or your closet or your desk drawer or your safe deposit box and just look at the will and see what day it was signed. If it was signed before January 2nd, 2013, call an estate planning attorney. The next day I want you to remember is January 1st, 2018. That's when the Tax Cuts and Jobs Act of 2017 became effective. And it increased the federal estate tax applicable exclusion amount. That's the amount that is excluded from being taxed at the federal level after you die. Before 2017, the threshold for paying federal estate taxes was much lower. And so if your estate planning plan was signed before that date, it may contain estate tax planning provisions that are no longer appropriate. And so your plan might be more complicated than it needs to be. We might be able to simplify things for you. So look at your will. Is it dated before January 1st, 2018? The next date I want you to remember is April 14th, 2003. In that year, the HIPAA regulations were passed. That's the Health Insurance Portability and Accountability Act. And that law imposed new restrictions on accessing private medical information. So this relates more to your power of attorney, your healthcare directive, your medical power of attorney, whatever you want to call it. The people that you love might have a hard time accessing information about your health. If you fall asleep, are unconscious, are in a coma, or otherwise unable to give healthcare professionals permission to talk to your family members about how you're doing or what's going on with you, they're not allowed to tell. They're not allowed to say how you're doing. They're not allowed to say what the disease or chronic health condition you have is. And so this is a permission slip for doctors, hospitals, and healthcare providers so that they can talk to your family, whoever you choose. And so if you're not married, but you have that special someone in your life that you would definitely want to be able to visit you at the hospital, well, they need a permission slip for that. So call an attorney if your estate planning documents were signed before 2003. Another reason you may want to update your estate planning documents is if they were prepared before you had children or when your children were much younger. I have lots of these clients coming in. They say it's been 25 years since they signed their last will, living trust, or tax-protected inheritance plans. Another reason that people tell me they're updating their plans is because their children are getting married or their children are getting divorced. Or if you've decided to add your grandchildren as beneficiaries to your estate plan, maybe it's because your grandchildren got married or your grandchild got divorced. Sometimes that plays a factor into how you want your children or grandchildren to receive their inheritance. Another question, another reason to update your estate planning documents? Have you changed your thinking about beneficiaries or about when, how, or how much they should receive? And that could be any number of reasons. If they're criminals, if they're addicted to drugs or alcohol, or if you've discovered that they're wasting their money and you don't want the money that you leave them to be wasted. Maybe you want them to receive their inheritance in a trust that's overseen by a trustee to make sure that the money lasts and that it accomplishes the goals and values that you've set out for them. Another reason to update your estate planning documents might be that you changed jobs, and so now you have different benefits through your work, like life insurance or IRAs or 401ks. It's a good idea to periodically, every few years, just ask your financial institutions, I'd like a summary of my beneficiaries. I want to see who's designated as beneficiary of my life insurance, my 401k, and my IRA. Because you might misremember what you did years ago. I had a client come in one time after her husband passed away, and she brought me this letter from the retirement company, and it said that she needed letters testamentary. So she was asking me to write a letter. I'll get into that more in just a minute. But the reason that the company said she needed letters testamentary is because her husband had not designated any beneficiary on the retirement plan. And she asked me, why wasn't a beneficiary designated? And I said, I don't know. I wasn't there when he was setting up his retirement account. Maybe you should call the HR guy and ask him why he didn't insist on a beneficiary being designated. And letters testamentary isn't really a letter from the attorney. It's an official court order that establishes who the executor is. And so what that meant is that we were going to have to go to probate court to probate her husband's will, because if there's no beneficiary designated, then the beneficiary is the deceased person's estate, and only the executor can act on behalf of a deceased person's estate. Another reason to update your estate plan is maybe you want to add, change, or delete charitable beneficiaries. Well, we got to take a break. Been talking about estate planning deficiencies. I'm Todd Marquardt, and definitely call the show, 210-308-8867. Ask your question, 210-308-8867. I'll be right back.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Most families don't realize they have hidden legal blind spots until it's too late. Wills, trusts, Medicaid planning, even protecting a business. These are the kinds of issues attorney Todd Marquardt helps uncover before they become problems. Todd is the host of Talk Law Radio, where each week he guides listeners through the legal challenges families, veterans, and business owners face, while showing them the practical steps to protect what matters most. Catch Talk Law Radio, Saturdays at 11 a.m. on 9:30 a.m. The Answer, 6:30 a.m. The Word, and now in Houston on AM 1070 and 103.3 FM The Answer, or anytime on YouTube. Planning isn't just about documents. It's about peace of mind, security for loved ones, and building a legacy that lasts. Don't wait for a crisis. Do it before you die.